welcome to the Animal Law Podcast. This is Marianne Sullivan, and today I'm so thrilled to be talking to the folks who are litigating the very first case filed by the brand spanking new Harvard Law School Animal Law Clinic. Professor Katherine Meyer, who you may remember from episode 13, will be joining us along with students Boanne, Wassink, and Richey, and they're going to be telling us about a case they have just filed in U.S. District Court for the District of Massachusetts. But actually, the case was just filed, but the situation started a long time ago, as they will relate in much greater detail. Way back in 2014, their clients filed a petition for rulemaking with the USDA, trying to get the agency to write some sensible rules interpreting the requirement in the Animal Welfare Act regarding psychological enrichment for primates. So far, they haven't heard anything since 2014. So, thus, this lawsuit. And before we get to that, I'd just like to quickly ask, of course, for your support in helping us keep Our Hen House, which produces the Animal Law Podcast, along with the Our Hen House podcast, going. And this is such an important time if you can manage it to support us, since through the end of the year we have a matching fund that will match your donation dollar for dollar if we manage to raise a total of $15,000. We're definitely not there yet, so we really need the help. And if you can help out, please go to ourhenhouse.org/donate. There you can join our special band of supporters, whom we call our flock, or you can make whatever donation you can afford and are comfortable with. But please do something, even if it's small. Believe me, even the small donations matter so much. They make us feel good, and also they impress larger donors. It really means a lot to us. So if you can manage something, and if you do get something out of this podcast, please do something. And every donation really does count. The only way to keep animal-friendly media going is through supporting its efforts. And in this case, that means supporting Our Hen House and the Animal Law Podcast. And, we really need to make that match or we're screwed. Also, I have one other announcement that I want to share. This one happens to be about this opportunity. It's not about Our Hen House, but it's about an opportunity for any law students out there who don't happen to be lucky enough to be at a school with an animal law clinic. And this opportunity is actually at the other brand spanking new animal law clinic. They're popping up everywhere. And that's, of course, at the Animal Law Litigation Clinic at Lewis and Clark Law School, one of my very favorite places, in Portland, Oregon. And it's now accepting applications for summer clerks, and they will be assisting the clinic with all aspects of civil litigation, advocating for farmed animals. This is specifically about farmed animals, so that's an exciting opportunity. And there'll be an emphasis on legal research and writing, and they're seeking students who have completed at least 36 law school credit hours by the end of this coming semester, and who have demonstrated strong research and writing skills, as well as an interest in civil litigation or animal advocacy, or both. For further information on applying, you can go to bit.ly/ALLCsummerclerk.com. And that is, I'll repeat that again, bit.ly/ALLCsummerclerk. That's one word, ALLCsummerclerk.com. And you can get a little bit more information there and find out how to apply. So now let's get to this interview. And I'm going to introduce all three of our speakers. First of all, Katherine Meyer, who, as I mentioned, you may have heard before in episode 13. She is one of the heroes of animal law, that's for sure. I can't even list all of the things that she's done. But she's currently, which is so exciting, a visiting assistant clinical professor of law at Harvard Law School. And she was a founding partner of the public interest firm Meyer, Glissenstein, and Eubanks. And that was hailed by Washingtonian magazine as, quote, the most effective public interest law firm in Washington, D.C. How about that? She has loads and loads of federal and state court litigation experience, including in numerous cases representing the interests of animals, including chimpanzees in captivity, captive orcas, endangered sea turtles, wild horses, pigeons, etc., etc., etc. She is a true hero of the animal law world. She'll be joined by Boanne Wassink, who is now a third-year student at Harvard Law School. And during her 1L year at Harvard, she discovered the field of animal law, and she quickly became involved through courses, research assistantships, the Animal Law Society, of which she is vice president, and now the Animal Law and Policy Clinic. It just shows you, like, when, if you build it, they will come. Like the fact that Harvard has put into place all of these ways for people to find out about animal law results in people actually finding out about animal law. Boanne has now decided to devote her career to helping animals through the legal system, and they will be joined by Richey, who is a member of the Harvard Law School class of 2021, and she also became interested in animal law since coming to Harvard, and she particularly hopes to advocate for the well-being of captive animals kept in research labs and exhibitions, and that will be a very exciting addition to the legal world when these women graduate. So let's get to that interview. It's pretty cool. Welcome to the Animal Law Podcast, Kathy and Boanne and Brett.
Thank you.
Thanks.
I've never had three people on at the same time before, and I'm super excited that I have you three on because everyone wants to know what's going on with the Harvard Clinic, with all of the clinics that are starting up. But you guys are really right out of the box filing this case like in November. How did that happen? So you're already filing a case. And I really want to talk to you about the clinic. I want to talk to you about some of, what's going on at Harvard. But let's start with talking about this case because I love that you're bringing this case. And let's just start with a little background. This case is about primates, and it's about primates used in research. So who are we talking about? How many primates are used in research in the United States? And what kind of facilities are they living in?
So our petition, this case covers about 106,000 primates used in research. And these primates are in all sorts of different labs at universities and other laboratories all around the country.
And what kind of primates are they? Are they mostly monkeys?
Yeah, so non-human primates, the most commonly used species, I believe, is rhesus macaques. And recently there's an increase in the number of marmosets also.
So all of these animals, in the condition, all of the animals you're talking about are covered by the Animal Welfare Act, right?
Yes.
And so tell us about this particular provision of the Animal Welfare Act that you are particularly concerned with and that specifically refers to primates.
So in 1985, Congress passed an amendment to the Animal Welfare Act that said that the USDA shall promulgate standards for a physical environment adequate to promote the psychological well-being of primates. So what's really important there is that the physical environment needs to actually promote the psychological well-being of primates.
And so how did that get passed? Do you have any history on that? Why Congress was particularly concerned with the psychological well-being of primates as opposed to other animals?
This is Kathy speaking. I've been around a little bit longer than these guys have in this community, so I'll answer that one. As you're well aware, Marianne, over the years, over the decades, there's been more and more research about the needs of primates, and particularly their social needs, their psychological needs. And by 1985, it was pretty clear that non-human primates, like human primates, have specific needs that are necessary to make sure that they are maintained in humane settings. And it was based on that body of research and concern by the animal welfare community that many of the animal welfare groups got together and basically lobbied Congress, and there were extensive hearings on this, to amend the Animal Welfare Act, which in general just requires standards for the care and maintenance of animals under its jurisdiction to specifically include standards that would promote the psychological well-being of these non-human primates that were being, at that point in time, used in research. And then it was extended to animals used in exhibitions and other enterprises that are covered by the Animal Welfare Act.
So I can imagine that the idea of these animal welfare advocates of what was going to be meant by psychological well-being is not exactly what happened. How do the regulations that were promulgated under the Animal Welfare Act carry out this requirement?
Yeah. So the regulations that are still in place today were passed in 1991, so they haven't been changed at all since 1991. And these regulations are unfortunately just a little bit lax and difficult to enforce because they sort of leave the promotion of the psychological well-being of primates up to the institutions themselves to create a plan about how they're going to do that, how they're going to promote the psychological well-being of primates. And the USDA doesn't have to actually look at those plans and doesn't have to screen those plans for any particular thing. So I think the biggest problem is just that it sort of lets the regulated public, lets the individual laboratory decide how they're going to comply with these regulations themselves. So it's just a little bit hard to enforce.
So I don't want to, Kathy, I don't want to go into the long saga of ALDF versus Glickman, but you do have personal experience with how in an enormous victory on a standing question, you actually had a very frustrating situation about how these regulations were going to be upheld by the courts, didn't you?
Yes, so we had a wonderful victory on standing to lose on the merits. That's what you're referring to. After we got the en banc ruling in 1998 from the D.C. Circuit that said individuals who like going to zoos to visit particular captive animals would have Article III standing to challenge agency regulations that were not adequately, did not adequately protect their psychological well-being. The case was remanded back down to the D.C. Circuit panel that had originally decided the case and on the merits. And looking at the case, the standards, quote unquote, standards that had been promulgated that Brett just briefly described, the D.C. Circuit said, well, there are some standards in here. There's some standards about cage size and that's a standard. And then they have these performance standards, which is thou shalt promote the psychological well-being of the primates. And that's really kind of a standard. You may not like it because it's not specific enough, but we can't say as a matter of judicial review that those standards violate the statute or otherwise arbitrary and capricious. So yes, we lost on the merits in that case. And that was in the year 2000. We're now in the year 2019, and a lot has happened since then in the world of primate well-being, and again, even more scientific knowledge about the needs, particularly the psychological needs of primates, which is a very short way of getting us to where we are now. And I'm sure the students can give you more background about what happened between the year 2000 and the year 2014. When our clients actually first submitted this petition to the USDA.
Yeah, that's definitely something I wanted to ask about, because you pointed out that even back when, in the 80s, when this statute was passed, there was an awareness that primates had these psychological needs, and now there's a whole lot more awareness of how complex they are. And can you talk a little bit about what the advancements have been in science since then?
Yeah, absolutely. So there have been great advances over the last few years, especially with regards to the psychological needs and the social needs of primates. So primates are exceptionally social animals. They need to be housed in large groups so that they have interaction with other members of their species. And so that's something that's really important, and something that the science has really come to embrace over the last few years is the need for social housing for primates.
So considering that these statutes are so vague and that these needs are so complex, and it's pretty difficult, I would imagine, for facilities to figure out exactly what is required, how are they enforced? Are they enforced at all?
They're not, really, and that's a problem, although, as I'm sure you know by now, and many people have talked about on your show before, the Animal Welfare Act in general is not enforced. There's no private right of action in the statute. And so enforcement is left up solely to the discretion of the United States Department of Agriculture, which is notorious for not enforcing that statute. There have been Inspector General report after Inspector General reports that have been issued over the years, which basically have concluded that the USDA really does not enforce the Animal Welfare Act. So it's not enforced as a matter of course anyway. And with these regulations in place, which as Brett described, basically leave it up to each regulated entity to come up with its own quote unquote enrichment plan for primates. That is just such a vague performance standard as it is, that even when the statute is going to be enforced, let's say there's a particularly egregious situation, the inspectors, who are the line people who go in to see whether or not these entities are in compliance with the standards, have no idea whether or not a particular plan is A, good enough, and B, being carried out according to whatever standards should apply to that plan. And so, and I think the students can tell you what has happened on that front since 1999. The agency itself has been looking at whether or not these regulations need to be changed, particularly in view of the fact that their own inspectors have been telling them that we don't know what this plan requirement means. We don't know how to enforce it.
Yeah, I think that's an ongoing story in enforcement of the Animal Welfare Act, that there are people who are doing this work who are a lot more eager to straighten out this statute and get it enforced better than the people in charge. Can you go into a little bit about whether that's happening?
So in 1999, APHIS, which is the Animal and Plant Health Inspection Service, which is the inspection kind of arm of the USDA, formulated a draft policy. And this was sort of trying to tell the regulated industry and also the people that have to enforce the statute how to interpret it. And so it identified 5 elements that it said were the minimum elements that were necessary in order to comply with the regulation about the psychological well-being of primates. So those 5 elements were social groupings, the social needs of infants, structure and substrate of the habitat, foraging opportunities, and manipulanda, which is the opportunity for primates to interact with things in their environment physically. So those were the 5 elements that the USDA said were the minimum things that needed to be addressed in order to comply with this requirement. And they also said in this draft policy that the regulated industry and the inspectors that were charged with enforcing the statute didn't really understand what was going on and didn't really understand how to comply with the regulations that were in place. So this draft policy was really important. It was published for public comment, and it seemed like a really good step towards maybe making more specific and more enforceable requirements under the statute. But the draft policy was never implemented, so nothing ever happened with it. And that's sort of the problem, is that this draft policy may have been really helpful if it had actually been implemented. And what it also shows is that as early as 1999, which was 20 years ago, the USDA itself acknowledged that the regulated public didn't understand what they needed to do to comply, and the USDA's own inspectors didn't understand how to judge compliance.
Yeah, I don't often have that much sympathy for the regulated public with these situations, but I can understand how they didn't understand what they wanted to do. They probably were pretty happy with that, but it is a little shocking how often this happens with the USDA, that there are people inside proposing useful things that just end up, always being a draft and not being a real policy. Now, I'm going to take a little bit of a detour because there's another important factual aspect to your lawsuit, and that has to do with standards that have been put forth by the National Institutes of Health, specifically for chimpanzees. And I'll just let people know that you're very enthusiastic about these standards, I think, and that's why they're relevant here. So let's just take a little detour and tell us what those standards would if they were applied to all primates and under the Animal Welfare Act, what would they require?
Yeah, so these standards were, as you said, for chimpanzees used in federally funded research. This was a study that was done by the National Institutes of Health, and they spent a lot of years kind of trying to figure out, what are the most important requirements to protect chimpanzees used in federally funded research. And so these are really specific. They would be able to be enforced. Some of these requirements are, as we discussed, social housing, environments that provide outdoor access, being able to climb a certain amount, being able to have enough things to do in the enclosure. They're pretty much what you'd expect, but they're much more specific about what actually needs to be in the enclosure, in the habitat, to promote all of these normal behaviors that the animal would have access to if they lived in the wild. So those recommendations were specific to chimpanzees, but what's really important is that they could be easily adapted to a variety of different primate species, because a lot of primates have pretty similar needs. They have social needs, they have environmental needs, they need things to do to occupy time, and they need to have space to conduct all of these behaviors that they would be able to do in nature, like climbing and building nests and all sorts of things. So while the NIH created these recommendations specifically for chimpanzees used in federally funded research, they could really easily be adapted to all sorts of different non-human primate species used in research in federally funded and non-federally funded research.
So it is my impression, I wonder if you have the same impression doing this research, that there's a strong tendency to very much dismiss the needs of monkeys and act as if they're like compared to chimpanzees, who have become very favored animals in the law and socially, to act as if their needs are very minimal. Do you see that kind of attitude? And I assume you would object to it if you did.
Well, yeah, you're definitely right. And I think a lot of it stems from, the way this law is progressing and the way we want it to progress it requires a lot of public education. And so we tend to use the species that are most like us to educate the public about their needs. And the chimpanzee obviously is a primate species that is very close to humans, both in genetic makeup, but also in terms of even how they look and how they act within their families, et cetera. And so people tend to get the chimpanzee needs more than they do other species needs. And that is why a lot of the animal welfare, animal rights efforts and litigation, et cetera, have used the chimpanzee as the model animal to advance that cause. And in doing so, certainly we would never want to have the public think that other species are less deserving or suffering less, et cetera. The other primate species that are used in these enterprises obviously do suffer, and so we don't want to pit them against each other by any means. But I think it's all part of the public education that is required to advance the cause of animal law. But I think what the students have done here with this complaint, and on behalf of our clients, is to basically say to the USDA, once the NIH standards were accepted for chimps, that make the case that there's every reason to accept the same kind of standards that your sister agency, the NIH, has adopted for these other primate species that are being used in research.
It's so hugely important that when we do litigate or advocate on behalf of these very special species, that becomes a stepping stone to extend it to other animals of other species who are just as much in need. And so I think this is a very, very important case because of that, because it's taking some progress that has been made, not complete progress, but a lot of progress has been made for chimpanzees, and saying, okay, we can't stop there. It's not just chimpanzees. So I'm really excited about this litigation because of that. Does the NIH require anything special for other primates, or it's really just NIH standards for chimpanzees that are the gold standard here? Maybe we shouldn't call it the gold standard because we'd better have them out of research completely. But
the better standard.
Yeah, the better standard.
Yeah. No, I think that's right so far. Anyway.
So, what is the relationship between the NIH and APHIS? How does this is there any real relationship? Are they influenced by each other? Is there a reason that APHIS could be encouraged to follow the example of the NIH?
Yeah, so they are both federal agencies, and they have in the past worked together a lot to work on animal welfare issues, since they sort of are both interested in promoting animal welfare. So they're sort of sister agencies, I guess. So there is hope that the USDA would really take seriously what the NIH found.
So let's get at long last, let's get to the lawsuit. Just start out by telling me who the plaintiffs are and who they're suing.
So the plaintiffs, there are three plaintiffs. So the plaintiffs are the New England Anti-Vivisection Society, which is NEVS, the Animal Legal Defense Fund, ALDF, and the International Primate Protection League. And they are suing the United States Department of Agriculture. As
you mentioned, they submitted a petition for, these three plaintiffs, I believe, submitted a petition for rulemaking a very long time ago. And we'll get to that timing issue in just a moment. And actually, we'll get to the substance as well. But first, can you just explain how a petition for rulemaking works? Who can submit one, and about what kind of substance?
Yeah, so anyone can submit a petition for rulemaking. There's a law called the Administrative Procedure Act, the APA, and it gives a lot of procedural rights to citizens. And so anyone can submit a petition for rulemaking to a federal agency asking them to do something. Anyone has the opportunity to submit that, and anyone that submits a petition under the Administrative Procedure Act has to get an answer from the agency, whether that's a yes or a no or something else, but they have to respond to the petition for rulemaking.
And what was the timing here? Remind me. I know you mentioned it before.
Yeah, so this petition was submitted in May 2014, so it was about 5.5 years ago.
And there's just been no response at all?
No response.
And does that happen a lot?
Yes, I would.
Let me just add. I mean, there was an initial response which we were actually quite pleased about, or our clients were, which was right after the petition was submitted. The USDA responded by saying, this is a very important issue. We're going to put your petition in the Federal Register and have public comment on it, which they did. They had actually 2 comment periods on it, which is really unheard of. Having submitted many citizen petitions over the years, it's very unusual for the agency to so quickly say, yes, we think this is worthy of publishing in the Federal Register and having public comment on. So at the time, the clients were very hopeful that this was going to lead to something quite substantive. But what happened was the agency, after having months of public comment on the matter and receiving over 10,000 comments in support of the petition, has just sat on it basically, and just it's languishing, and they just have never given our clients a substantive response one way or the other on the petition, and that's the basis for the lawsuit.
So, Kathy, I'm going to ask you this question because of your long experience with the USDA and with APHIS. And I just want, it's something I kind of alluded to before, that you get the feeling that there are 2 camps within APHIS, and some of them are really trying to do the right thing, and then they are blocked. Is this a sense that you get from, you have much more experience here than I do, that there's kind of a conflict within the agency itself?
I think that's true with most agencies. A lot of the career people who are very dedicated to the mission of their agency would like to see more done, particularly with respect to the protection of animals under the USDA's jurisdiction, and often advocate for stronger standards, for more enforcement, for more inspections, for tighter restrictions on renewals of licenses, for those kinds of things. And what happens is, as these matters make their way up the policy or political chain, they get quashed, basically. And that's because, the regulated industry has a lot of power that it exerts over the agency and Congress and the administration at this point in time. And, all of these kinds of improvements for animals that we would like to see implemented cost money and cut down on where money could otherwise be spent or profits. And therefore, oftentimes, these regulated entities are very much opposed to these initiatives, and so they quash them, and they have the ear of the people in charge at the agency and even above the agency.
So it's kind of the career bureaucrats opposed to the political types. Where have we heard that before? Does that sound familiar?
Yes, it does.
All right, let's not go off on a tangent here. So just tell me, basically, we've covered a lot of this background. So can you just, and so you don't have to go into this in great detail, but just make clear what exactly did the petition seek?
So the petition is seeking an answer to the 2014 rulemaking petition.
And it would like a yes answer, by the way.
Yes. Yeah. The petition basically calls for the USDA to implement similar regulations to those NIH recommendations for chimpanzees and federally funded research, as we talked about, and asking them to tailor those recommendations to fit the needs of the species of primates that are most commonly used in research, and to implement those types of recommendations.
Now, you mentioned, Kathy, that the industry is generally opposed to all of this sort of thing because presumably it costs money to treat animals well. We all know that. If you have a dog, you know it costs money to treat animals well. So give us an idea of how much upheaval would be caused in the research world if they had to treat monkeys and other primates with the amount of decency you are requesting here.
Well, I mean, I can't quantify it. I'm sure if you wanted to talk to someone on the other side in the biomedical research world, they could probably come up with a number. But it's going to cost some money to meet the needs of these primates and give them more space and house them together and let them have access to the outdoors and let them have things to climb on and let them have materials to make nests out of and let them have appropriate substrates in their cages, as opposed to just putting them in barren cages by themselves with nothing to do, which is what is right now, unfortunately, the common denominator. So yeah, it's going to cost some money. On the other hand, two things. Of course, they're worth it. I mean, these are breathing, living, sentient beings who are being experimented on for humans, for the benefit of humans. And so, given that they are basically sacrificing their entire lives for our well-being, our benefit, they deserve to be treated with a certain modicum of humanity, of humanness, I guess I should say. Number one. Number two, what our clients discovered when they were putting this petition together, and there's plenty of research out there on this, and we mention it in the complaint, is that these experiments, this research that's being done, can very much be adversely affected. The research outcomes that are desired here can be very much adversely affected by the anxiety and the stress that these animals have to endure as a result of these minimum standards that are now required. And so it's kind of a win-win situation. Spend the money treating the animals who are, sacrificing their lives for us in a somewhat better situation. We're not saying release them all to the wild, although that's certainly, we don't like to see any animals used in research this way. But if they're going to be used in research, they should have minimum standards that address their psychological well-being, something Congress decided in 1985. It's been a long time since then. And secondly, it's going to help with the outcome of the research, because you take a stressed out animal and do some research on it that you intend to benefit humans in the long run, and the research results are going to be skewed because you're using stressed out, anxiety-prone, hypervigilant animals because of the way they're treated. So it's not really in the best interest of the research outcomes either. So
it's such there are so many compelling arguments for this, and it boggles the mind that we're still doing it. Yeah. They're still doing it in such incredibly primitive ways. Even there's been research even that mice, animals less complex than primates, that psychological conditions can affect outcomes of research. So yeah, well, stop me. I have to get back to the lawsuit. Obviously, the lawsuit is in very early stage. It's just been filed, and but can you just tell us? And you mentioned before that they have to respond to petitions, and that they often don't respond to petitions. So what are the legal requirements, and what do you have to do to get them to follow them?
Yeah, so basically all the law says is that agencies have to respond to rulemaking petitions in a reasonable time frame. So pretty much we're arguing that the 5.5-year delay on this petition is unreasonable, and that there's no reason why the agency couldn't have given our clients a response in the last 5.5 years.
So one of the obstacles that's always been present, of course, for animal advocates in bringing lawsuits like this is standing. You have not yet gotten there. Do you want to discuss it? What your standing arguments are, or would you rather I shut up?
No, that's a good question. Standing is definitely something that we think about a lot as animal advocates. Luckily, the Administrative Procedure Act, which is the law that gives people the opportunity to submit rulemaking petitions and gives them a right to get an answer on those petitions, conveys standing. So the plaintiffs, because they submitted this petition, they have standing to bring this unreasonable delay case to get a response to their petition, because the law requires that they be given a response in a reasonable time frame.
And have you thought about Article 3 standing under the Constitution? Like, are you, have you been injured?
Well, this is Kathy. The injury so far is not getting a substantive response to the petition as required by the Administrative Procedure Act. If we get a decision that we don't like and we want to sue over that substantive decision, then we would have to assert additional standing on behalf of whoever the plaintiffs are in that lawsuit.
Okay. Well, we'll wait for that to happen.
They'll grant the petition, and we won't have to do that.
They'll grant the petition totally, and everything will get fixed. That's what usually happens. Well, you never know. At some point, somebody will do the right thing here. Yeah. So, assuming that does happen, or assuming that you at least get them to respond to your petition, what will happen? Will they write new regs? Will they do? I mean, presumably they won't just copy your petition into the law or into the regulations. Will you then have to sue them again if they don't do what you want? Is this just an ongoing process?
It's always an ongoing process, Marianne.
Up until we all drown from climate change, we're going to just keep going on. Yeah.
Gosh, how long have we been talking about these issues? Well, I mean, my position would be that they could just grant the petition and promulgate the regulations, because they've had comment on it. They had a round of public comment on these regulations, on these proposed standards.
So are you implying that one of the things that they might do is ask for more comment, and you think that's just silly because they've already done it?
Yeah, they could do that if they really wanted to dot all their I's and cross all their T's and make sure that the regulated industry could not sue them for not having sufficient comment. But I think they've already had. I mean, they had quite a bit of comment on this specific petition. So these specific standards that we have proposed. Now, if they're going to promulgate really species specific requirements for each of the various species that are still being used in research, that probably will entail more scientific expertise brought to bear with respect to what are the proposed standards, and probably another round of public comment to make sure that the agency is fully informed of all positions on this before they actually promulgate a final regulation. Now, if they deny our petition, at that point in time, we would have to take a look at the grounds that are provided for the denial, and in consultation with our clients, obviously figure out whether or not we would have to bring a second lawsuit challenging the denial on arbitrary and capricious abuse of discretion grounds.
Mm-hmm. We'll be looking forward. Well, actually, I'm not looking forward to that, because I think they're going to grant your petition.
Okay.
We're going to go with the positive here.
Again, the whole strategy, as you quickly noted, and we stress in the complaint in this case, was to basically ask for a very modest request, which was just take what the NIH has already said is required for chimpanzees, and make sure that the same kinds of minimum standards apply to other species of primates used in research. So we're not really asking for the moon here. We're only asking for what USDA's sister agency has already said is required for psychological well-being with respect to one species, and asking the USDA to apply that basic principle to other species as well.
Yeah, both on substance, because why shouldn't they have the same needs and have those needs fulfilled in the same way, but also just as a practical matter, this has already been figured out. These regs have already basically been written for another agency, but so that does reduce the amount of attention that would have to be paid to actually making this happen.
Yeah, a lot of research and a lot of time and effort went into those recommendations on the NIH's side, and so if the USDA can benefit from that expertise and all of the work that they did, then that's awesome.
Well, it'll be really exciting to see how this goes, how quickly you can get an answer out of them. And, as I said in the beginning, it's so exciting that that you were able to file a case so quickly in the semester. And so I want to ask a few questions about, the clinic, which everybody is super excited about. And so, Kathy, are there particular subject areas that you are expecting to focus on? Is this case a bellwether? Because you are an expert in the Animal Welfare Act. And do you expect that to be a major focus of the kind of cases the clinic will be bringing?
Well, we're kind of doing a wide variety of projects. I guess I would say, obviously, we're doing some on the Animal Welfare Act, but also including a legislative project. We're very involved right now. Students are very involved in helping the U.S. Congress on the House side support legislation that was introduced this summer to revamp the Animal Welfare Act and make the enforcement provision stronger, principally by creating a private right of action. So we have students who are working on that on behalf of clients, putting together the evidentiary basis in support of that effort. And we're doing a lot of cases and a lot of projects in a wide variety of subject matters. I mean, our jurisdiction is over animals, and so we construe our jurisdiction very broadly. And we have projects on climate change. We have projects on food, the intersection of food and animal issues. We have a farmed animal project. We are doing some work with Oceana. There are some things I can't talk about because they're subject to attorney-client privilege, but we construe our jurisdiction here at the clinic extremely broadly. And basically what we're trying to teach these students is how to get out there in the world and do the kind of advocacy that will be effective in protecting animals wherever they may be and whatever legal hooks and legal strategies we can come up with.
That's really, really exciting. And if you guys manage to get a citizen supervision for the Animal Welfare Act, you will make me very, very happy.
We're trying.
So, Boanne and Brett, how I know you haven't been doing this too long, but what do you see as the benefits of the clinic for your futures as lawyers?
This is Boanne. So I see it as huge. So this project is, we as students are working together to write a complaint, file it, every stage. We are very, very involved. Kathy is great at supervising us. And I mean, she keeps us from doing anything too crazy, but she...
Kathy? Really?
Marianne knows me too well.
Well, she keeps us from doing anything. She keeps an eye on us. She guides us. She lets us learn from her great wisdom. But and now she's posing. Anyway, but it's phenomenal experience to get real hands-on litigation experience as a student. So, I mean, to use myself as an example, I'm a third-year law student. I'm trying to do what she just said, go off into the world and use every legal hook I can find to make things better for animals. And so, if I want to be an animal litigator, what better experience is there to do animal litigation on real substantive matters with a really, really experienced mentor who can teach you everything anyone ever knew about it? I promise it isn't just because I want a good grade.
She had me at hello.
I have heard through the grapevine that Kathy is already very beloved there, and I assume that my grapevine is pretty reliable. So I will take you at your word. Brett, how about you? How has the clinic been working for you? And I noticed in your bio, actually I noticed this in both of your bios, that you actually became interested in animal law while at Harvard. So tell me a little bit about how that happened as well.
Yeah, absolutely. So I took animal law with Professor Kristen Stilt, who's an absolutely phenomenal professor here at Harvard. I took her animal law course last year when I was a first-year law student, and I just absolutely loved it. I was deeply concerned about a lot of the issues that we talked about. I learned a lot about things that I didn't know were going on. I learned a lot about the different types of legal strategies that attorneys are using to help protect animals, like the Animal Welfare Act, the Endangered Species Act, some of the sort of international ways of protecting animals that work or don't work sometimes. And so I think that was what sort of got me interested in trying to see what I could do to help the problems that are going on even in our own country with regards to how animals are treated in a variety of different settings and exhibitions and research labs as pets. And so animal law is an extremely broad field. And that class sort of just introduced me to all of the different things that kind of fall into animal law and made me really want to get started on working on some of these issues. And so I was really, really excited when I found out that the clinic was first starting up this fall, because it's a great opportunity, like Boanne said, to get hands-on litigation experience. But also, we're actually doing things. We're actually out in the world right now helping animals, or trying our best to. And so I think that's really awesome. I think it's great that we can do it in this environment where we can learn to be better lawyers and better advocates for our future careers. But we can also try to have an impact right now and try to take on these projects that really need someone to take on. And so that's why I love the clinic.
Oh, that's really, really, it's so exciting to me. I can't even tell you, like, that this is going on, to hear your enthusiasm, to know what's going on at Harvard of all places. And I just think we may be at the dawn of a new era. I really hope so, because the last era wasn't that good. And thank you so much for joining me today, telling me all about this. And thank you for bringing this case. I'm super excited about your work, and I really want to stay on top of it.
You are so welcome, and thank you, Marianne.
Thanks so much.
Thanks for having us.
Thank you so much for joining us on the Animal Law Podcast this month. We'll be back next month with a new show, and thank you so much to Kathy, Boanne, and Brett for sharing their thoughts and expertise with us. I really enjoyed this episode. Thank you to Michael Herron and John Frusciante for their help in producing the podcast. And if you like what you hear, please subscribe on Apple Podcasts or your favorite podcatcher. Consider leaving us a good review on Apple Podcasts, which really helps us find new listeners. And if you are able, please consider making a tax-deductible donation at ourhenhouse.org/donate. Thanks so much for tuning in.